Good afternoon, everyone, and thank you for joining us in our 2024 complimentary webinar series covering the FAR, or Federal Acquisition Regulations. We are coming to you live today from Washington, D.C., and we're glad you all could make it. Okay, a bit about this series. As usual, all of our webinars are complimentary and recorded. The FAR has 52 total parts. Today we have come to our last part. The recordings and PowerPoints will be posted within 24 hours of the webinar's ending, and you can find the recordings on our YouTube channel simply by subscribing to it using the link you see on the screen. You can find the PowerPoint on the SlideShare site using your LinkedIn credentials to log in. And we also offer sponsorship opportunities. If you're interested, please send us an email to hello@jenniferschaus.com. Please note that we covered the FAR in 2020, so if you're eager to learn more, navigate to the Webinars tab and scroll down to the section, the FAR 2020. Because it has been 4 years, many of the regulations have changed and been updated, so please use this as a reference tool only. And now a bit about us. We work with established federal contractors worldwide, helping them to navigate the market. Our services range from market analysis reports to contract vehicles and compliance. Some of the contract vehicles we support are listed here on your screen. For more information, please visit our website. Okay, those are our services for federal contractors, but we also provide marketing and advertising services for organizations who are selling to federal contractors. We can add the extra muscle to your marketing efforts via our newsletter ads and webinar sponsorship to in-person events. Please email us and ask for our media kit. We are currently offering a discounted offer on our newsletter, which reaches over 34,000 subscribers. If you want to place an order or have any questions, please send us an email to hello@jenniferschaus.com. As you know, congressional hearings on both the House of Representatives and on the Senate side are open to the public unless otherwise stated. We typically have a list here of the upcoming schedule, but Congress is currently on recess, so please check out our newsletter for more information on hearings in the future. Please join us for our Summer Shorts webinar series. This August, we'll be hosting 30-minute GovCon webinars with industry leaders. The series runs every day for 2 weeks, starting on Monday, August 12th, and ending on Friday, August 23rd. The webinars will begin at 12 p.m. Eastern Time, and as usual, they are free to join. Both the registration and the recording links can be found on our website under the tab Webinars. Here's the lineup for week 1. These leading ladies in the federal sector will cover various topics, including contract finance, contract management, capture, pricing, and compliance. In week 2, we will look at capability statements, BD, marketing, subcontracting, and M&A. Again, these webinars are complimentary and recorded. Please join us for these upcoming complimentary webinars with various Apex accelerators. Jennifer will be covering GSA schedules as well as federal marketing for our local Apex accelerator in Virginia. These are complimentary and online webinars, so please join us. She is also teaching a class for the Maryland Apex Accelerator on GSA schedules in December. And she will also be speaking for webinars with the East Michigan Apex Accelerator. She will be covering GSA schedules and federal marketing. So look out for these dates in November and December. Our webinars are complimentary thanks to our longtime and generous corporate and in-kind sponsors. Please allow me to introduce them. We would like to thank our friends at GovEvents, the premier platform for posting events related to government and government contracting. You can find all of our webinars and our events at govevents.com, as well as recordings from our past 700+ webinars. We also want to thank Tom Johnson and his team at Set Aside Alert, the go-to publication for contracting opportunities for small, women-owned, veteran-owned, HUBZone, and 8A firms. Visit setasidealert.com for more information. The Fairfax Economic Development Authority has an online calendar of events and webinars. We want to thank them for posting our events and webinars on their calendar. The Virginia Apex Accelerator at George Mason University offers free one-on-one counseling to established government contracting firms in Virginia on federal, state, and local procurement topics. If you are interested in learning more, please use the links provided to explore their services, review homework recommendations, register for live training, and find useful links to agencies and other self-directed learning. One-on-one counseling is limited to eligible client companies. Appointment requests are handled in the order they were received and based on counselor availability due to high demand. Online resources and group trainings are free with no restriction on business location. Join the Greater Reston Chamber of Commerce's monthly GovCon Council meeting to network with peers, learn about upcoming events and opportunities, and help to shape future programming. The meetings take place the fourth Tuesday of each month at 8:30 a.m. The Greater Reston Chamber of Commerce. The next meeting will be on August 27th. Do you want help winning government contracts? Bidsby can help. Users can find contract opportunities from federal, state, and local government. Additionally, you can search for teaming partners, incumbent point of contact, expiring contracts, compliance matrices, and also proposal templates. Create your login today at bidsby.com. Bidsby is an official partner of the U.S. Small Business Administration's ETG Empower to Grow program. Events are the ultimate engagement channel to bring government and industry together. 68% of government personnel report that they attend more than one event each year. The Federal Business Council, or FBC, has worked with government and industry for 45 plus years to create gatherings where ideas are shared and to help government achieve its goals. This includes agency industry days, cybersecurity symposiums, technology expos, and offsite meetings. FBC provides full lifecycle meeting planning and event management. With over 5,000 meetings under their belt, FBC has the experience, systems, and personnel to make your next event exceptional. Learn more at fbcinc.com. Now, last but not least, please check out our friends over at GovBrew. GovBrew is the most read GovCon newsletter, keeping thousands of GovCon professionals in the loop with news, updates, and opportunities in the federal contracting market, all in a fun and accessible email that only takes 5 minutes to read and is 100% free to join. It goes out every Monday, Wednesday, and Friday at 7 a.m. It's filled with great content, event posting, webinars, and more. We encourage you to sign up at govbrew.co, or you can use the QR code you see on the screen. Now, the reason we're here today is to cover FAR Part 52. Please welcome Michelle Coleman and Sky Matheson. They are both partners at Crowell & Moring to the webinar. We're so glad to have you with us today and are excited to hear your presentation. I'll put myself on mute and turn the floor over to you now. Just let me know when you want to get to the next slide.
Perfect. Thank you so much. And on behalf of Michelle and I, this is Sky Matheson, we appreciate you all for joining. In addition to being partners at Crowell & Moring, one of the largest government contracts law firms in the world, Michelle and I are both former Air Force. We were procurement litigators over at the Air Force. And now we handle all aspects of contract disputes, cost recovery, general compliance. We're going to be going through all of these compliance rules today, as well as cost accounting, labor, and many other topics. We do both litigation and counseling, and we specialize in creative ways to recover costs. Let's go to the next slide, please. So today we're covering FAR 52. Just at a very high level, some of you may have joined the other parts. FAR parts 1 through 51, everything leading up to this, is essentially the regulations and the instructions for the contracting officers, what do terms mean, what clauses to put in what contracts. FAR Part 52 are the actual clauses that appear in the contracts. These are the bilateral agreements that the two parties, if they're here, would agree to. We've got the little denotation from the FAR that shows when we talk about the slides today, when we talk about the clauses 52 to 43-1, for example, those are just the regulations and where they come from, but those are also the names of the clauses. Next slide. The FAR contains a big matrix of all of the different clauses and when and where they should apply and how they should apply. We're going to be covering many of the important ones today, so we're not going to cover this matrix. We just want to flag that it's there for you for your review. Next slide. In general, again, FAR parts 1 through 51 is how the contracting officer, the instructions of which clauses to put in some of this and which clauses, FAR 52 clauses, appear in the contract. Some of it is at the source selection stage, some of it can be negotiated during performance, but in general, the CO, the contracting officer, has a list of clauses that should be in the contract based on the anticipation of what the contract type is going to be. You can negotiate clauses to get in and out, or to modify them, or to deviate from them, or to tailor them. The FAR has rules on that using alternatives. There's many FAR 52 alt clauses, the alternative versions. So you can take a clause that might be specific to a firm fixed price, and you can use the alt version that might be specific to a time and materials. Or the alt versions have just different timing. Submit something before award with your proposal package, or after award, things like that. There's different alternative clauses that we can talk about some of those today, and we're happy to answer questions about that as well. Let's go to the next slide, and we'll start getting into the roadmap of moving away from just the general FAR 52. What is it? These are the clauses. Again, they're regulatory clauses, but these are the contract clauses. You can also have H clauses where the parties specifically tailor their own clauses that aren't necessarily the boilerplate FAR 52. But today we're just going to be covering the more kind of regulatory boilerplate FAR 52 clauses. And with that, I'll turn it over to Michelle to cover the revenue granting clauses, the main ones that kind of the bread and butter of government contracts here, changes and delays.
Thank you. Next slide, please. Okay, so as Sky mentioned, we're going to walk through all of the sort of common remedy granting clauses. We're going to start with changes because this is the bulk of the types of issues that you see in government contracting, changes and delays. So you guys have already had your instruction on Part 1 through 51 and 52, as I mentioned, are the clauses that are going to be implemented into the contract that are required for the contractor. And so these changes clauses here, as you see, there are different types based on the contract type that is in your contract, or the type of your contract, excuse me. And as you'll see, and we'll go to the next slide, if you were to pull up these clauses in the FAR, you will see that they're very similar. The biggest thing that you'll see is that they talk about the contracting officer being able to make changes to the general scope of the contract. But then there are some subtle differences of the types of changes that the government or the contracting officer can make within that general scope. But generally, they're very similar unless we're talking about the commercial products and services clause, and we'll hit on that a little bit. Now, under these remedy granting clauses, under the changes clause, changes can be made unilaterally or bilaterally. Unilaterally meaning the contractor does not have to sign, there's no approval by the contractor, the government can make that change on its own. Those types of changes are generally made to the sort of administrative items under the contract, changing a SLIN or an ACRN. It can also be making changes to the scope within that, within the stated changes that can be made within that clause. The government can also do that unilaterally. And Skye's going to talk a little bit about terminations, but terminations can be made unilaterally as well. Now, bilateral changes, these are an agreement between both parties, and that's going to be generally for anything that the parties can agree to, specifically something that's in the general scope of the contract, however, can't agree to something that's outside of the scope or could be considered a cardinal change, for example. But however, you can agree to those changes within the general scope or even to the terms and conditions of the contract that may not necessarily fall within the changes clause. You've got express changes. Those are the changes that are made by modification in writing between the parties, whether unilateral or bilateral. Or you have constructive changes. And constructive changes are the types of changes that are made either orally by the contracting officer or happens. We often see these happen in meetings. The parties are talking about parts of the contract, the requirements, maybe the interpretation of the contract. The government interprets it one way, the contractor interprets it a different way. That could be a constructive change to the contract, or it might be some action by the contracting officer or inaction by the contracting officer that constructively changed the contract. For breach, we sort of mentioned it here, and that's the statement that I made about cardinal changes. So the breach is really only occurs when there's a cardinal change to the contract. Why? Because the contract includes the changes clause, which says the government or via the contracting officer can make a change, whether unilateral or bilateral to the contract. So really, the only time there's a breach related to a change is when it's a cardinal change. That's something that's completely outside the scope of the contract. It's not related. No offeror would have considered it to be a part of the contract. It's those types of things that would be considered a breach. And it's important to understand the difference between what is a permissible change, whether it's express or constructive, or a cardinal change, because with cardinal change where there's a breach, technically a contractor could stop performing. And I'll talk a little bit about the disputes clause later, but the disputes clause requires contractors to continue to perform. And certain instances, depending on whether you have the alternative clause or not in your contract, you may not be allowed to perform, to stop performance. So it's important to seek sort of counsel before determining that there's a cardinal change and that the contractor can stop performing. A couple other key things here is contractor has to notify the contracting officer of change, typically within 30 days, but read your clause. The remedy for a change is an equitable adjustment, and that's the cost of the change plus the reasonable profit. And as I mentioned before, commercial products and services, we have commercial items on the clause, not called that anymore. Those changes have to be made bilateral, and the important part there is that case law has said that there's no constructive change if it's a commercial products or services contract, and the changes have to be made bilaterally. Next slide, please. Next slide, please. All right, so the next, Can we go back to delays? The previous slide, thank you. So now we have delays and stop work. And so this is another sort of big sort of ticket item that happens when you're working on government contracts. There's changes, or there may be changes and there may be delays. And so we're not going to be able to go through all of these clauses because we don't have that much time. But it's important for contractors to be aware of these clauses and what they mean, and that they essentially are another sort of remedy granting clause. So when there is a delay, there's some sort of equitable adjustment for the contractor, whether that's an equitable adjustment for cost and schedule, or just for schedule. Usually, these clauses sort of cover instances where the contracting officer, by their action or inaction, has somehow delayed the contract, being late approving procedurals, being late approving a design that impacts the contract. Any sort of thing in that nature could be that's going to cause a delay. It might fall within one of these clauses. Now, the stop work order is a little different. Usually the government issues an order and says, need you to stop work, and there's certain requirements for that stop work. Under all of these, you could have sort of a constructive component to it, sort of similar to what we have with changes. You can have an express change or a constructive change here. You can have sort of a delay specifically falling under this clause where the government's saying they're going to have to delay you, or a constructive delay, which we often see the most, where the government has done something and it's not by official order, it's not official stop work order, but it's stopping your performance or delaying your performance. Contractors are still able to recover under these clauses based on constructive delays or constructive stop work. As I mentioned, some clauses allow for equitable adjustments that include costs, and some are just schedule. Excusable delay clauses are going to be just a schedule relief. They're not going to entitle a contractor to recover costs. And it's important to sort of take a look at these clauses, because some of these clauses may allow profit recovery and others may not allow profit on the recovery of cost. And it's also important, very similar to the changes, to make sure you're notifying the contracting officer of the delay. But one thing to note here is where there might be a dispute over whether there's a delay. If the contracting officer denies a valid extension request, so you're asking for a schedule extension, it's valid, and the contracting officer denies it because they disagree, the contractor can also claim constructive acceleration. It can recover under the constructive acceleration theory. That would entitle the contractor to recover the cost of accelerating. That might include sort of overtime, hiring new individuals, cost to add an additional shift. All of those sorts of things are going to be recoverable under the constructive acceleration theory if the delay was it was a valid delay, the extension, and the contracting officer denies that valid request for an extension, and you have to accelerate to be able to meet that deadline that the contracting officer did not extend. Next slide, please. Okay, so differing site conditions. These are generally for construction contracts, but there are two types of differing site conditions. One, if the request for proposals represents that the site is going to be a certain way, and when the contractor gets there, the site differs materially from what the government said it would be. That's type one. Type two is if the site is materially different from what industry might expect. So you sort of know the site's supposed to look one way. There's no sort of express language in the RFP that says it's going to look a certain way. When you get there, it's something that's completely outside of what anybody in the industry would have expected. The important part here is notification. The contractor, if they're encountering either type 1 or type 2 differing site condition, needs to promptly notify the contracting officer before disturbing the site. That's to allow the contracting officer to determine whether they want to continue to move forward, depending on the time that might take to fix the site based on the differing site condition or the additional cost. It's important here to note, again, commercial items, that should be commercial products or services. There's no clause here, but there is still a remedy if a contractor is performing constructive construction services that are commercial. then that differing site condition would just be a common law breach claim. Like all the other remedy granting clauses, there is an equitable adjustment. If a differing site condition is encountered, the contractor can recover cost and schedule impacts related to that differing site condition. But again, it's really important to notify the contracting officer because that differing site condition could be denied if there is no notification or if that request is made after final payment. Next slide, please. All right, so the next is another common remedy granting clause, and that's government furnished property. Many contracts require some sort of government property, equipment, or information. Contractors that receive property or equipment are going to be required under these clauses to make sure they have a system in place to manage that property, so they're properly handling it while they have it in their possession, they're properly returning or disposing of that property. Now, the government can make adjustments to the property or information or equipment that they're providing to the contractor under these clauses. They can add more, take some away under those clauses. And if they make those sorts of changes or adjustments to the property that's going to be provided, the contractor is entitled to an equitable adjustment, and that's an equitable adjustment to cost and schedule. And it's important for contractors who maybe have some, where there may be some changes related to the GFB clause, to ensure that it's not just like you're looking at the contractors just looking at the costs related to having to replace the equipment or item that the government has now said they will not provide, but any sort of downstream cost impacts related to not having that property or not having the property in a usable condition. And it's another important thing to note here that, the government takes its property very seriously, as it should, and any sort of misuse of that property could result in fines, imprisonment, or both. So it's important to make sure you have a system and that the employees who are handling the government property and equipment or information is doing so properly. Next slide, please. All right.
Great.
So next up here, we've got the roadmap. Sky, over to you.
Great. Thank you so much, Michelle. So over to terminations, and we'll go to the next slide. Terminations is next. There's two main types of terminations. Again, Michelle noted that these are unilateral. So the government is unilaterally terminating the contract. Now, how and why they terminate the contract has major cost implications for the contractor. Some types of terminations are for the government's convenience, is what it's called. This is an old principle that goes back to the Civil War. Basically, if the government just decides that it's in their best interest, they don't want this contract to keep going, they don't need it anymore, or for other reason, they can terminate it for convenience. We have those clauses cited. There's a number of them depending on the type of contract. This is a very common one. Again, the government it doesn't mean you did anything wrong. It does mean that the government just simply doesn't want this vehicle anymore. They want to maybe end this procurement and figure out what to do with the funds, or they simply want to do a different procurement to do it a different way. So termination for convenience is where we're going to start. Again, if the government terminates, that's their right. It's not a breach. The contractor is entitled to certain things, but there's also certain obligations that to be aware of. So certain things are due in 1 year of the termination for convenience. You absolutely have to get in your termination for convenience settlement proposal. That is the list of all of the costs that you might be entitled to. Now, what costs are you entitled to? Where do you look? Well, first you look to the FAR 52 clause. So the termination for convenience clause, a standard one, for example, the 52249-2, standard fixed price termination for convenience. It has a big list of different types of things that you could be compensated for. And it also cross-references you over to the FAR 31. So maybe a few months ago, the FAR 31 webinar that went on, that's where all of the cost principles are contained. And there's one cost principle, FAR 31.205-42, that lists all of the costs that you can and cannot recover in a termination. And so, again, you submit a cost proposal, it's due in a year. You can submit it earlier, and it lists all of your costs. Some of those costs are the lawyer fees of preparing your termination for convenience proposal, any accounting fees, all of the material that was in progress that you've started to make, but you haven't delivered to the government yet. So obviously you haven't been paid for it yet. The government reimburses you for the costs of these material, plus they tack on, overhead and profit. Any of the other types of costs that are contained in FAR 31, so maybe just not even material that's in progress. Maybe it's kind of unamortized costs that you thought you would recover if you had been able to perform the entire contract, but because of the termination, you are not able to recover them all, but they've already been incurred. So there's all sorts of moving parts of things that you might be entitled to, special tooling, special equipment. There's specific tests for those. The easy ones that the government always agrees with are what are kind of called the settlement costs. Any storage costs that you have to incur, like I said, the legal fees, the accounting fees to prepare the termination. Those are settlement costs. Those are usually the least controversial, but you put together the proposal, the government has opportunity to audit it, to negotiate it, and then hopefully you reach agreement on the termination settlement proposal. Another milestone deadline to be aware of is within 120 days, so not at the 1 year mark, but earlier, you need to submit an inventory schedule of all that potential government property that Michelle had just talked about, and allow the government to figure out how to dispose of that. Termination for default is a very different type of a termination. That's where the government has decided you have done something wrong, and you are either in non-compliance with the contract, or you're endangering performance of the contract, or they're afraid you're not going to finish, or you're late, or you're otherwise saying that you're not going to perform. And they have the right to default terminate you. The common one for fixed price contracts is FAR 52-249-8. And essentially what happens at a default is the government says, you're done, your contract is over, you have lost your right to proceed, and they now have the right to come after you for certain costs, and they have the right to go and get a reprocurement contractor and potentially assess reprocurement costs, the difference of what the new person is going to charge versus what you charged. They can assess that back to you at the end of the reprocurement performance. So default, there's a lot of the cost in a termination for convenience that you can recover. Default, you can't recover those, not all of them. You can recover some, certainly items that are finished, but the default has a lot of implications, and this is where an area where if you let a default termination stand, it can look bad in the SAM's database, and other contracting officers are going to be able to see in the future. You've had terminations for default. It's kind of a bad look, and so typically you're going to want to be challenging those terminations for default. When the government does issue that unilateral modification that says this is a termination for default, you have 90 days to appeal that to the Board of Contract Appeals, or a year to appeal that to the Court of Federal Claims. But you're going to want to appeal that and try to get that either settled or reversed. If you do get it reversed, then essentially the regulations say that the termination for default, the government, it was improper, and it's converted into a termination for convenience, and so you get to recover all of your costs that you would under a termination for convenience. Default's important. There's some areas where the government might owe you a cure notice. So a cure notice essentially is a government letter that says you have 10 calendar days to fix or to cure whatever the alleged problem is. They owe you that if the allegation of default is you're endangering performance or failure to make progress. If you're late, like you miss a deadline, they don't technically owe you a cure notice. And if you repudiate the contract, you say you're not going to perform, they don't technically owe you a cure notice. Next slide. So again, these are just a few more of the talking points there below in red that we wanted to highlight for you. On this slide, I guess I'll look at the slight differences of the commercial items. So Michelle talked about the commercial item clause 52-212-4. Paragraphs L and M are their T for C and T for D, the termination for convenience and default. What's really interesting in the commercial item termination for convenience, which is that paragraph L, is it does a completely different way at looking at the cost recovery. So if the government decides to terminate you for convenience and you have a commercial item contract, instead of getting your inventory schedule, showing them all of the costs incurred, which requires kind of sophisticated contractors who have cost accounting in their books and showing general ledgers of where costs tie out to what, and the government, like I said, audits those. If you're a commercial item contractor, they try to have slightly easier rules so that you don't need to come forward with all of this complex cost data that the government can go through and audit. Instead, you're looking at a different test. The paragraph L test is a percentage of completion. So you look at the items that you are doing, whether they're products that you're making or services that you're performing, and you try to show, CLIN 1 required me to deliver 10 items. I delivered 3, so I'm at least 30% done, and I was halfway done with the next one, right? So I'm 35% of the way done with the contract, so you owe me 35% of the price. That would be just an example of how you would calculate it. It gets a lot more complicated if there's many items and are all in different states of production. What is production? How far is beginning 1% performance if you start buying supplies? There's a lot of open questions out there, and that's where Michelle and I help contractors get the maximum recovery possible under commercial item termination for convenience, or Michelle and I help with just regular, if you are subject to cost accounting rules, the FAR 31 rules of the termination for convenience, we help there. Again, maximizing recovery is the important part, and then responding to a termination for default, that has massive implications, and we want to help get involved and get that reversed so that there's no bad black mark on your record, and then also recover as much as possible. Next slide. Turn over to Michelle for business ethics.
Thanks, Sky. So this is a really important slide, and really all of these slides are really important, but it's going to be really important for government contractors to understand the rules, the business ethics and compliance rules. And while this part is a lot larger, especially if you were on the webinar series that talked about business ethics and compliance in a little bit more detail, I won't be able to go through all of that. So we sort of highlighted these two key pieces. But I think the important thing to note from this slide is that you have to have, as a contractor, a business ethics and awareness and compliance program, with the exception of small businesses or commercial products and services contractors. If you fall within that category, just double check by taking a look at the FAR and those clauses to see what the requirements are. And it's also important to have a system to report when something has happened. So there are requirements for mandatory disclosure if someone in the company or a subcontractor has violated federal criminal law, if there's fraud, if there's a conflict of interest, bribery, or gratuity violations, or if there's a violation of the False Claims Act as well. It's really important to keep this top of mind because it can have some serious implications for contractors. It's also important to make sure you've got the system to report things and that you've got the hotline posters to make sure that your employees and subcontractors and anyone sort of who enters the facility is aware of their responsibilities and who to call when there is an issue, so that those mandatory disclosures can be made. Thanks, Sky. Over to you with the next slide.
We'll go to the next slide on costs. So there are many FAR clauses dealing with costs or pricing. We've got some of them on the next two slides, and then we're actually going to cover some of them on future slides. Essentially, you can bucket cost or pricing for this topic into 3 buckets. There's the cost accounting standards, CAS, and that's in the middle there, FAR 52. It should be 230, and the main clause that it makes it applicable is 230-2. And apologies for the typo there. So that's the cost accounting standards. That's one big bucket, probably the most onerous and most difficult to comply with. It's a series of rules dealing with cost allocability. The next bucket is the ones at the top. These are what's generally called TINA, or defective pricing. These are the requirements for certified cost or pricing data. We'll cover those. So there's 2 buckets, CAS, TINA, and then at the end, we'll deal with things that are called FAR 31 cost allowability rules. We'll cover that at the end. So let's start at the middle, FAR 52 230-2, and again, apologies for the typo there. Those are the cost accounting standards. The most onerous and complex of the rules to comply with, but also the easiest to be exempt from. So it would be an entire day to talk about what it requires at a high level. It requires consistency in many things, consistency in proposals to performance, consistency in how like costs are charged and allocated in different like circumstances. It deals with home office allocations. It deals with, what is your period and making sure that period costs are allocated correctly. There are all sorts of rules. for these purposes, whether they apply or not is the determinative factor that we're going to cover, which is, if they don't apply, then you don't need to worry about them. You might see the CAS clause in your contract. So if you see 52-230-2, the clause itself is self-deleting or self-executing. It says, if CAS applies, then here's what you need to deal with. So whether it applies or not is the question. The easiest kind of framework of how it would not apply are the exceptions. If you have a commercial item contract, so again, we talked about commercial products, commercial services, you would be exempt from CAS. You have FAR Part 12 acquisition. If you have a competitively awarded firm fixed price contract where you didn't submit certified cost pricing data, that would be exempt from CAS. If you've never received a CAS contract before and your contract that you're bidding on is under 7.5 million, then you would not be covered by CAS. Or even if you had a CAS covered contract this year, if this contract or this opportunity is less than 2 million, then it would be exempt from CAS. Those are the four main buckets. There's many, many more. Be aware that CAS applies to contracts, not to contractors. So each contract is either CAS covered or not. It applies, it attaches or does not attach at award. So it doesn't, if you get a modification that adds to the threshold, it won't make CAS apply. It either applies or it doesn't at the time of award. And other things just to remember is, the subcontracts that you have might be subject to CAS in addition to the prime contracts. It does change the analysis slightly on the exemptions, particularly FAR Part 12. But again, just these are CAS covered subcontracts or prime contracts. Hopefully you're not subject to them. And if you are, it has a wide amount of compliance rules that you'd want to get in contact with a lawyer to make sure that you're doing everything correctly. Let's talk about the top bucket, TINA and defective pricing. So TINA at a high level is a statute. It stands for the Truth in Negotiations Act. That was the old historical name since the 1960s. It's still generally what people call it. It now has a slightly different name, the Truthful Cost Pricing Data Act, but it's still generally referred to as TINA. It's a disclosure statute. It requires disclosure of certain information. It is not a use requirement. It doesn't require the parties to use any particular data, just the contractor to disclose data. The idea of TINA is that when you have particularly a sole source firm fixed price contract where the government doesn't have competition, you have to buy what you're buying from this one vendor. The vendor has the ability to have extremely high prices, and the government has to take those prices without visibility into how those prices were arrived at. So the statute says in certain circumstances, if it applies, the contractor needs to disclose all certified cost of pricing data. We're going to talk about what that is. What are those circumstances? So TINA will not apply if it's under $2 million. So that's similar to a little bit of the CAS that we just talked about. TINA will also not apply, like the CAS that we just talked about, if it is a commercial item, commercial product, or commercial service that you're selling, or it won't apply if it's a adequate price competition. So there was either in a civilian context, there was the expectation of more than one bidder, and in the DoD context, there actually has to be more than one bidder. So if there's adequate price competition, or at least just right competition, then you can be exempt from TINA. If you have to comply with TINA, what do you have to do? You need to certify and submit all facts that as of the date of price agreement, the government, reasonable business person, would want to know that could affect prices significantly is essentially the test. The government, would want to see everything, and they have pretty deep requirements. And so if you are required to submit it, you need to submit all facts. You don't need to create new data. You don't need to analyze any particular data. You don't need to use any of the particular data in the actual pricing negotiations, but you do need to disclose what you know. So if you know that there's 3 different vendors who sell different products, and one is cheap and meets the requirements, and one is expensive, and you plan to use the expensive one because they are subjectively in your mind better, that's fine. For pricing purposes, you can use the better, more expensive one. But for TINA disclosure purposes, you need to disclose the knowledge that you have that there is a lower cost vendor out there. That's essentially how it works. It applies to, if it applies, so we talked about what it is and how it can be exempt. If it applies, it requires disclosure. What does it apply to? It applies to all prime contracts that are not exempt from TINA. It applies to contract modifications. So even if you we're exempt from TINA at the time of award. If now you're the performing contractor and you're a year into performance and the government gives you a modification that's over $2 million, that modification, you're the sole source on it. It's going to be subject to TINA. So just be aware that it applies to the prime contracts and the mods. It also applies to subcontracts and modifications, where again, the same tests and exemptions don't apply. So if you have a subcontractor that you're going to sole source to, and it doesn't meet any of the exemptions, then the subcontractor is also going to be subject to TINA. So they need to submit all of their certified cost of pricing data to you or to the government to discharge their obligation, and they need to collect it from their downstream. Anyone downstream, as far down as you want to go, that is sole source and not exempt from TINA. So those are the TINA rules. Again, that could be an entire 2-day seminar just talking about TINA, but at a high level, those are the clauses to be looking at. The last bucket at the end, the last 3, and then the next slide, is essentially FAR 31 and unallowable costs. Maybe we go to the next slide, please. So we're not going to rehash FAR 31 because that was the subject of a earlier webinar series on FAR 31. But just again, FAR 31 is a set of rules of what costs are allowable. It might apply to your contract based on type. If you have just a straight firm fixed price contract that was competitively bid, it might not apply at the time of award, but it might apply to the pricing contract modifications downstream. It'll always apply to FAR 31 unless it's a commercial item. To terminations for convenience, unless it's a commercial product or commercial service, in which you have a different termination for convenience rule. So FAR 31 can kick in if you have a cost reimbursable contract, cost plus contract. It's always going to be applied. FAR 31 and the allowability rules are always going to apply. T&M contracts, the M is a material cost. You're billing, you're invoicing the government for a cost. You're seeking reimbursement, and you have G&A markups on that. Those G&A markups are going to be filled with your own G&A costs. All of those G&A costs are subject to FAR 31. At a high level, FAR 31, if it applies, requires all your costs to be reasonable, allocable, allowable. Substantiated is an easy one for them to just allege things are not substantiated, put the burden back on you. There's a whole host of rules, but just be aware that the government has certain rights that if they allege your costs are unallowable, then they can remove them from a pricing proposal, or if you've already charged the government, they can ask for that money back. If they believe the costs are expressly unallowable, named and stated in FAR 31 as being unallowable, then they might be able to assess penalties as well. Let's go to the next slide. Invoicing and payment, a little bit to do with FAR 31. If you have a T&M contract or a cost plus cost type contract, but just in general, invoice payment applies to everything and how you submit it. So the payments clause there, our second bullet, is the main one that you'll have. It apply, firm fixed price contracts. You get done with your month. You submit an invoice for the month. It might be pro rata, 1/12 of whatever the annual cost is. It might be based on something else. We're going to cover a lot of the different clauses of what it could be based on. You might be invoicing per product that you're delivering, per deliverable. You might be invoicing, like I said, on a 1/12 pro rata per month. You might be invoicing based on certain services, certain milestones. Performance-based payments at the bottom, 52.232-32, is certain milestones achieved. Once we've accomplished, the initial kickoff meeting, we get to bill for 10%. Once we accomplish the initial, research report, we get to bill for another 30%. Performance-based payments can be making payments on a finance basis during different steps of performance. The third from the bottom, progress payments, is a way to take an otherwise firm fixed price contract and make it essentially cost type billing, right? So I get to submit it's a firm fixed price, but I don't need to wait until 5 years when I'm done building the building. I get to submit my progress payments as I build. Here are the costs that I'm incurring, and the government reimburses you about 80% of those costs. There's a lot of other clauses that are a little bit less common than the 3 we just talked about. I will say that the allowable cost and payment clause, 52.216-7, is an absolutely vital clause for cost type contracts. That's a clause that determines on a cost type contract, even if you have a cost type CLIN, how you invoice for costs and what are allowable, and that cross-references and brings in all the FAR 31 rules. There's also another clause that's not up here, but in case you have a time and materials contract, time and materials contracts have their own invoicing and payment clause, which is 52.232-7. There's many, many rules, and every contract's gonna be different, but that covers the waterfront on the types of rules. Go to the next slide. Ordering clauses we'll cover very quickly. There's many different types of contracts that have the government's ability to place a contract and then continue to order additional quantities. So it's very different than a firm fixed price contract where everyone handshakes, you're going to deliver 10 items, and then you start performing. An indefinite quantity contract, like the ones we have listed here, are ones where the government enters into agreement with you, but what you're going to be delivering and when you're going to be delivering it and the quantities you deliver are going to be determined later down the road. The major types of contracts are either that are indefinite quantity is the bottom one, indefinite quantity type contracts, and requirements contract right above it. They're very, very similar. Both of them have no definite quantity stated. They're going to have firm fixed prices for the quantities when they happen. A requirements contract has no minimum guarantee. So you might go 5 years and they never place an order. The consideration for a requirements contract is exclusivity, that they give you and exclusively you some benefit to something, either the only one who's going to perform the contract or a geographical region or a type of service. Indefinite quantity contracts have a different type of consideration to make them binding. There might be multiple people with indefinite quantity contracts, so there's no exclusivity, but they'll have a minimum quantity guarantee that we don't know what we're going to order and when we're going to order it, but we'll promise you at least $50,000 to stand ready to give us the capacity to perform if and when that happens. Those are the two main things. They're very, very tricky. Michelle and I litigate and counsel on these all the time. There's massive areas where the government will make allegations that, while close to true, are not necessarily letter of the rules, and we're able to help the contractors either to avoid disputes or to recover costs if the government tries to come after them. There's also the way that the government places orders that can get contractors into trouble. The government's placing task orders at the end of an IDIQ. The government's ability to basically take a 5-year IDIQ and try to stretch it out for more years down the road. Certain things they can do, certain things they can't. It's really all about the ordering clause and how that's structured. So again, lots and lots of tricky requirements, very nuanced requirements. There might be a lot of money at stake, might be a lot of no desire to continue performing for years and years on options, on task orders down the road. We help and counsel on this all the time. Next slide. Turn over to Michelle on labor and employment.
Thanks, Sky. So labor and employment can have some complex rules, and there are often changes, particularly to the wage requirements for employees of contractors or subcontractors. So it's really important for contractors and subcontractors to kind of stay apprised of these types of changes. So I'll walk through the FAR clauses that we have here on the slide. FAR 52.222-8, that requires contractors to maintain payroll and basic records information during the course of the contract, and then for 3 years thereafter for laborers and mechanics. Those payrolls have to be submitted weekly to contracting officers. There's got to be a statement of compliance signed by the contractor or subcontractor, and there's a requirement this requirement applies to subcontractors as well. Any sort of falsification of records related to payrolls or those basic records is considered a false claim and could subject the contractor or subcontractor to civil or criminal prosecution. Now, FAR 52.222-14, that's disputes concerning labor standards. And I think the important thing to know about this clause, which is very short, is that disputes related to labor standards requirements are handled by the Department of Labor and their disputes process. There's a disputes clause in the contract as mentioned before, and we'll talk about a little later. Those types of disputes are not handled under the disputes clause. The Contract Disputes Act, or the disputes clause, does cover disputes related to the interpretation of contract or even payment under the remedy granting clauses related to construction and the Service Contract Act payments that contractors get to recover, and I'll talk a little bit about those. But sort of anything else where it's like the classification of an employee or the types of the type of wage determination that should be applied to the contract, that's going to be a dispute between the government and the Department of Labor, or the contractor, the government and the Department of Labor, and not handled under the disputes clause. FAR 52.222-30 through 32, those are the construction wage requirements. It says you have to pay wage in accordance with the wage determination got to make sure that you're using these proper labor categories and the people meet those requirements, and that wages and fringe benefits are being paid in accordance with that wage determination. And these clauses allow for recovery. So if there are increases or decreases in wages at certain times, like an exercise of the option, then a contractor can seek recovery for those increased wages or fringe benefits. That's very similar to the Service Contract Act. The clauses 222-43 and 44 sort of implement that portion of the Service Contract Act that relates to contractor payments to employees. It applies, this clause applies to prevailing wages and collective bargaining agreements. It permits an equitable adjustment for any actual increase or decrease in the applicable wage and fringe benefits based on certain circumstances. If it's by operation of law, if there's a change under the Fair Labor Standards Act, or if there's a Department of Labor wage determination applicable on the anniversary date. Key to remember here is no profit over overhead for contractors. Again, rules can be tricky here. We help contractors with this. We do it in conjunction with our labor and employment attorney, so it's important to sort of consult an attorney if you have any questions. And I'll take it over back to you, Sky, on the roadmap.
Great, thank you so much. Next slide. So we're gonna, the rest of these rules are all very, very important, but can each be tricky and like labor, involve other practices. Let's go to the next slide. Options is one, just easy to cover. The bottom three of these black bullets are important. The government can extend things. How do they extend? The bottom one, the -9 clause, they extend the term of the contract, usually by a year, but it could be a different period, no longer than a year, typically. That's how the government basically takes a 1-year contract, turns into 2, to a 3, to a 4. The -8 clause is different. Option to extend services. Essentially, it's a bridge idea where even though the contract is ending, you had a 5-year contract, now the government wants, in order to bridge until they get the next contract in place, they have the option, not the obligation, to exercise this option and get an additional 6 months of services at the prior rates from the prior year. And then the -7 is separately priced quantities. So if you have quantities that are all listed as, these widgets are $5, they can add more quantities under the -7 clause. Just be aware, there's a lot of disputes on these. A lot of disputes. We listed some case law here at the bottom, but essentially, if the government effectively exercises an option, which happens all the time, they're a day late, or they try to do an option exercise and a modification at the same time, things like that, you might be entitled to your cost performance and not precisely what the prices are in the option. It's all very tricky, but this is a good place to reach out to lawyers who can help craft kind of creative ways to recover as many costs as possible. Let's go to the next slide. International trade. Again, this is one where we have an entire practice group dealing with trade. We've got lawyers that specialize in government contracts and the intersection of government contracts and trade. These are the clauses that you'll typically see in the contract. Michelle and I get to deal with them and on a compliance side, but these are all very, very tricky. Buy American clauses and trade agreements clauses, those first two, BAA or TAA, as you might have heard them, and there's a BABA that just came out as an act. They have very similar tests, but different, whether it's manufactured in the US, domestic manufacturing, or domestic transformation of a product. And there's all sorts of exceptions and other countries that are listed. Anyone essentially subject to a multilateral trade agreement for TAA, for example. So whether or not you have to comply with these or not, and who down your supply chain needs to comply with them, is a really tricky question that we typically have specialists that focus on that. Just be aware that the clause itself is how you buy your things, and so it might affect which of your vendors, because all your vendors are going to be subcontractors, which of your vendors you can or can't use. Let's go to the next slide. Limitations clauses. The main two limitations are there in the middle. 52-232-20 is the limitation of cost. So in a cost type contract or other contract that's funded, you would have a ceiling. Essentially, the limitation of cost is the ceiling. In no event is, are you allowed to incur costs that go above this cost ceiling? That would be the high starting point. So you might start low and you know what your maximum ceiling is. The one right below it usually is in conjunction with that. So the -22 is the limitation of funds, or LOF. The LOF clause is even if your ceiling, even if your limitation of cost is $1 billion, if the government only incrementally funds your contract by $1 million, then you have two ceilings that you're working under. One is the clear and present, one that you're going to be focusing on, which is they only incrementally funded this $1 million under the limitation of funds clause, the -22, and I need to make sure that I don't overrun that limitation of funds. These clauses are really, really important. They're strictly construed by the courts. These have fiscal appropriations aspects to them. So make sure that you comply with what the clauses say. Important things to remember, these have notice requirements. Typically, when you're within 60 days of incurring 75% of whatever your limitation is, you would notify the government in writing, the contracting officer in writing. It's really, really important. If you miss that notification or if you're late on it, the government's got defenses. Also, be aware that the clauses tell you that you don't need to overrun. If you reach the ceiling and the government hasn't added more funds, you can stop work. Too often we see contractors just assume or presume that they're supposed to continue performing over the ceiling, and then they get into trouble because now you're coming back to the government asking for money where the clause itself says you're supposed to have stopped. So again, just being aware of these clauses. There's also limitation of liability and limitation of government liability. Those work similarly, but in different contexts. Let's go to the next slide. Data rights and IP. Again, very, very quick touch on this. If you are developing something or you've already developing something that you're selling to the government, just be aware that you want to protect your data rights. The government is not typically looking to own intellectual property, with certain exceptions, but that's just in general. The government, wants you to have the IP typically, but they always want to get data rights in the data, the rights to use what you're selling to them as much as possible with as low cost as possible, perpetual kind of unlimited rights to use the data. You want to make sure that you really carefully protect your data rights. How you do that is going to depend on the acquisition. We've got some of the clauses here, but essentially record keeping is really, really important. Making sure that you've kept track of how you developed, what costs you spent to develop at your own private expense, what you're selling to the government now, or if what you're selling to the government now uses as a component something you developed at private expense, that you're making sure the government doesn't have some later right to say they bought the whole thing or they invested in the whole thing, such the government has unlimited rights or government purpose rights to use that. Also be aware of marking, which is even if you've protected your rights from a data right standpoint correctly, you need to make sure that anything you transmit to the government that's going to have the appropriate markings. What those markings are going to depend on what you've asserted, but make sure that you have the markings that comply with the FAR and DFARS clauses. It's really, really important because if you submit things that are unmarked, you might have otherwise protected your rights, but if you submit something that's unmarked, you might give the government some arguments that they get the rights to use at no cost. Next slide.
Thanks,
Michelle,
Guy. Thank you. So we'll talk a little bit about inspection and acceptance. I think that one important thing to remember here is it is the contractor's requirement to inspect its own goods and services before it gets to the government. That is required by the Contractor Inspection Requirements Clause, and it just makes good business sense. However, if the government, receives goods and services that are not properly were not inspected and are damaged or do not conform to the requirements of the contract, then the inspections clauses, which are different depending on the contract type, but also very similar, kind of like the changes clauses that we looked at earlier, it's important to note that there are certain things that the government can do. The contractor has to make their supplies and services available for inspection by the government at no increased cost to the contract. That includes subcontractors. Late supplies or services could result in the government charging the contractor for additional tests or cost of inspection, to the extent that there's some impact there. Also, the government can reject non-conforming supplies and services and require correction at no additional cost or replacement at no additional cost, or seek an equitable adjustment for the contractor if the government decides to accept that item as a defective item, but they'll make sure they get the equitable adjustment for the loss of value or whatever it might be that they're not going to be getting because it's non-conforming. The government does have to inspect promptly, but that doesn't necessarily relieve the contractor from responsibility unless that, the government's failure to inspect promptly is grossly unreasonable. Now, the contractor does have some rights here. The government can't over-inspect, and the contractor can recover for that. If the government does that, the contractor can also recover if the government's determination or rejection of an item is unreasonable or improper. And again, these apply to the subcontractor as well. If we could go to the next slide, please. The next slide is on subcontract. There are various clauses related to subcontracting, and we're not going to be able to hit on all of these, and hopefully you can listen to the webinar related to this part of the FAR. I'll just do a sort of a general overview. It's important to note the term subcontractor is defined very, very broadly. So it's really important, particularly when you're sort of looking at certain requirements, to see if there's a specific definition of subcontractor there, or if there are sort of laws or regulations that might say what a subcontractor is. Sometimes you have that. It's also important to check these clauses, any of the FAR 52 clauses that we've talked about, or we have the topics of which we touched on, but we may not have talked about that particular clause, because they may require flow down. Usually you see it in the last paragraph. It'll tell the contractor if that clause needs to be flowed down to the subcontractor. So it's really important to make sure those clauses are flowed down for both the government's protection, but also the prime contractor's protection as well. And as the slide says, the prime contractor is responsible for the subcontractor performance. There's sort of no way around this, including subcontractors the government might direct the contractor to select and require to perform. And then there's some other requirements here. It's just important to kind of take a look at these clauses before entering into a subcontract. Make sure you don't, if consent's not required, if consent's required, that you're following sort of all of those requirements. We could go to the next slide, please. And next slide. All right, so the last slide here is on disputes, which is the most fitting way to end FAR 52 clauses. You see FAR 52-233-1 that talks about disputes or protests. Contractors can protest solicitation improprieties and improper awards. That can be done either to the Government Accountability Office or the Court of Federal Claims. Contractor claims, that's Sky and my sort of bread and butter. A claim is written demand asserting as a matter of right the payment of money in a sum certain, the adjustment or interpretation of contract terms, or other relief arising under or relating to the contract. Claims that are over $100,000 must be certified, and that claim starts the disputes process. Claims have to have a sum certain. You can't guess. It's not, we think we might be entitled to 20 million. You have to be entitled to 20 million. However, you can make adjustments to sum certain throughout the disputes process. Claims can be made by the government or the contractor. A final decision, the contracting officer's final decision is required on a claim, and that decision is binding unless the contractor appeals it to the Board of Contract Appeals or the Court of Federal Claims. There is a 6-year statute of limitations for claims. It's not jurisdictional for the boards or courts, but it can be used as defense in the government to prevent payment to a contractor, or vice versa, payment to the government if it's a government claim. Now, successful contractors receive CDA interest, or Contract Disputes Act interest, from the submission of a claim until they're paid. So this can result in big money depending on the claim value and the time to resolve. We don't talk, the dispute clause doesn't talk about request for equitable adjustment. There are some clauses that are in contracts that talk about request for equitable adjustments. They look very similar to certified claims. They do not start the disputes process. They're usually submitted to help the government, bring the government to the table and negotiate, or bring the government to the table and negotiate. But you have to submit a claim within 6 years to meet the statute of limitations requirements. So that means you'd have to, if the REA negotiations are unsuccessful, you need to convert that REA to a claim. The difference is there's no Contract Disputes Act interest on REAs, but you can recover attorney preparation costs or consultant preparation costs on REAs. That's not recoverable under claims. So that's it. I mean, this is the end of our session here. We're ending on the disputes, and please reach out to us if you have any questions or need assistance with anything.
Yes, thank you all.
Thank you both for an informative presentation, and thanks to everyone for joining us today. As mentioned, you can find the recording on our YouTube channel within 24 hours, and you'll find over 700 webinars on government contracting there. Thank you everyone for joining us, and thank you, Michelle and Sky.
Thank you.